Please welcome to the stage the National Constitution Center's interim president and CEO, Vince Stango.
Good evening, everyone. On behalf of the National Constitution Center, welcome. I'm Vince Stango, interim president and CEO, and we're delighted to welcome everyone joining us here in Philadelphia and those watching online from across the country. I'd like to begin by thanking Professor Neil Siegel and our partners at Texas A&M Center on the Structural Constitution for their collaboration in making tonight's program possible. We're also grateful to our distinguished moderators and panelists for sharing their expertise with us. There are a few moments each year when the American people focus more closely on the Constitution than the conclusion of a Supreme Court term. The court's decisions shape our laws, define the powers of government, address questions about individual rights, and influence the national conversation for years to come. This is why conversations like this matter. The National Constitution Center was created to increase awareness and understanding of the Constitution on a nonpartisan basis. Our role is not to tell people what to think, but to invite them into the conversation, to explore the Constitution, wrestle with difficult constitutional questions, and learn from scholars and practitioners who bring different perspectives to the same text and traditions. Our Constitution has endured for nearly 2.5 centuries, not because Americans have always agreed about its meaning, but because each generation has inherited the responsibility to interpret its principles, preserve its institutions, and continue the work of constitutional self-government. That spirit is especially important today. Just days ago, America marked the 250th anniversary of the Declaration of Independence. Here in Philadelphia, millions gathered throughout Independence Week to celebrate our nation's founding. At the center, we see that anniversary not as a conclusion, but as the beginning of a civic decade, the period leading to the 250th anniversary of the Constitution in 2037, and continuing toward the 250th anniversary of the Bill of Rights in 2041. It is an opportunity to reinvest in our civic institutions, renew our civic infrastructure, and strengthen the habits of citizenship that sustain our constitutional democracy. This evening's Supreme Court review reflects that vision. Our speakers bring different interpretive philosophies and professional experiences, but they share a commitment to serious constitutional inquiry. Together, they model the kind of constitutional culture we seek to foster, one grounded in intellectual curiosity, historical understanding, careful reasoning, and mutual respect. That exchange of ideas is one of the enduring strengths of our constitutional tradition. Thank you all for joining us and for being a part of this important conversation. It is now my pleasure to welcome our first outstanding panel. Sarah Isgur, senior editor at SCOTUSblog and legal analyst for ABC News. Frederick Lawrence, of Georgetown University Law Center. Kannon Shanmugam of Davis Polk. Keith Whittington of Yale Law School. And they are joined by moderator Professor Neil Siegel of Texas A&M School of Law. Neil, the floor is yours.
Hello, everyone. Welcome, and thank you, Vince, for that very generous introduction. As he said, my name is Neil Siegel, and I'm honored to co-direct the Center on the Structural Constitution at Texas A&M University School of Law, along with Professor Lawrence Solem. The center has a really great partnership with the National Constitution Center, and as part of that partnership, we co-host an annual Supreme Court review. The Supreme Court doesn't really do much these days, so we're going to have to figure out ways to fill the time. But in order to accomplish that task, I have with me a formidable team of Supreme Court experts. Sarah is the editor of SCOTUSblog, which is the premier legal blog about the Supreme Court. I use it all the time. It's so good they use it inside the Supreme Court. She's also a legal analyst for ABC News. Fred is a distinguished lecturer at Georgetown University Law Center, and he has been doing this event for as long as this event has been done.
And a little longer.
And a little longer. And so thank you, Fred, once again for answering the call. Kannon is a partner at Davis Polk. He's a premier Supreme Court advocate as well as a thoughtful commentator on the work of the court. And then finally, Keith is the David Boies Professor at Yale Law School. He also happens to be, in my humble opinion, one of the great political scientists living in the United States today, as well as a very prominent originalist legal scholar. So this panel is diverse along a number of different dimensions. All will inform what I hope will be something special that we can create together this evening. Let's begin by looking at the forest before we dig into the trees. Share with us your big picture takes on the term. How would you characterize it? How do you think it might be mischaracterized or has been mischaracterized? How is this term unlike all other terms, right? Anything you want to share with us to help put this term in perspective. And we'll begin with Sarah and then work our way down.
I think that when we take the Supreme Court in individual terms, we miss something very fundamental about the Supreme Court itself, which is they don't really live in single-term cycles. They don't live in two-year election cycles like we tend to do. They live in much longer-term horizons. And so I actually think the way to think about this Supreme Court term is to put it in with the last 10 years or so and say that the Supreme Court has been on an executive power project, that the current constitutional crisis is the failure of Congress to exist anymore, poke with a stick to see if it's dead, and that the presidency has now been trying to fill in the gaps. And so the Supreme Court, over the course of the Biden administration and the Trump administration, has had several important rulings, not every term and not necessarily more than one in a term, but that therefore the most important ruling that we just got to add to that project is the tariff ruling. It was really important for that project's purpose that you followed up on the student loan forgiveness case from the Biden administration as soon as there was a new president who was trying to do the same thing, and they did. The case that I think will actually go down as least important will be the birthright citizenship case. I think it's actually a pretty idiosyncratic question of law about the 14th Amendment. And so while we got 194 pages, some of which is nap-inducing, I think that will look a lot more like CASA from last term. We spent a whole lot of time talking about it because it came out on the last day, and then we never really referenced it ever again because it doesn't matter in our day-to-day legal existence, even when we are talking a lot about the 14th Amendment and different visions for what that second founding of the United States meant.
Thank you. Thank you. Fred.
So you were good enough to mention that I've been doing this since the beginning. This is my 26th year doing the Supreme Court review. And I'm just going to keep doing this till I can get it right. That's the idea. So you may have to put up with me a little bit longer. It seems to me that this is a time of not just my little anniversary of 26 years, but we're thinking a lot of 250 years of the country. And as we just heard, coming up in a few years down the road, 250th of the Constitution. So thinking of this term in terms of the last 10 years, but also tracing this now all the way back, it seems to be one of the great geniuses of the American political system was its adaptability. You could think of this in sort of evolutionary biology terms, that we have been in a advantageous adaptation to change. And one of those great changes, starting in the late 19th century and on through the 20th century, was understanding that a big legislative body would simply never be able to address in real time the kinds of issues and challenges that were ultimately going to be put upon government with respect to health, with respect to safety, with respect to protecting free markets, with respect to protecting consumers. And so what you would need is some kind of agencies that would do that based on expertise that would obviously be affected by the political process, but would have some staying power from administration to administration. You obviously see where I'm going with this, right? This is the administrative state, and the administrative state that, with all of its flaws, largely allowed for a dramatic change in the American socioeconomic system over the past 100+ years. Slaughter is the case that I would focus on, as put in double harness with Loper-Bright overruling the Chevron doctrine from 2 years ago. It distinctly curtails that ability to experiment. And the fact that we are, through the lens of a court that is placing government in a fixed structure, now an 18th century, late 18th century structure, makes it very hard to adapt going forward. It's true that there's been an expansion of the executive branch, and that as a result of that, you get a narrowing of the legislative branch. And yes, there's obviously some ways in which the legislative branch gets an extra point here, the tariff case, that Congress is going to have to deal with tariffs. But the fact that Congress no longer has the power largely to deal with voting rights, whereas we thought they did, where Congress no longer has the ability to set up administrative agencies and have them largely independent from political powers, which we thought they did. And so in those ways, you do have a contraction of congressional power. But I want to pick up on an interesting observation that Justice Gorsuch seems to make as his big project, and to ask a question about it. The project of saying, this is what Congress now is going to have to do if it wants more power. Has to be much more focused on how it legislates, has to be much more specific on what it says, and isn't it time that Congress picked up the oar and actually did what it's supposed to do when it, to row the way it was meant to row? The problem is, in 2026, that is completely unrealistic. That is not how Congress operates now, and it's hard to imagine any time in the foreseeable future when it will. So as an abstraction, it makes sense to hold Congress accountable for that. But in the concrete, what it does is it makes it very hard to govern. Or put differently, it allows government by executive order, because that can be done, but legislation becomes very difficult, and legislation beyond a certain point will even be struck down. One last very quick point to watch is a continuation of a way in which, if you have to predict a case just based on the parties, putting your money on a corporation against anyone else will largely give you high predictive value. That's how the court will come down. So how do we square Slaughter and Cook? Cook saying that the Fed is in fact independent, but other agencies are not. Well, don't ask me, ask the Chamber of Commerce describing its great victory in those cases, when it says that Slaughter allows less regulation that's not completely controlled by the particular executive in power, whereas Cook gives you predictability from the Fed. Those are the two things they want. Those are the two things they got.
Well, Sarah and Fred have been loath to express their opinions, and so we're going to turn now to Kannon, and he's going to...
Oh, I should mention that I run a not-for-profit that is a nonpartisan organization. The Phi Beta Kappa Society is nonpartisan, so all the views that I express might as well be those of the Phi Beta... No, are not the views of the Phi Beta Kappa Society.
Kannon.
Well, first of all, thank you to the National Constitution Center for having me. It's a real privilege to be a part of this panel. In true advocate fashion, I'm going to make 3 points, but I'll make them very quickly. The first is that I think that Sarah has identified the problem that explains a lot of what has been going on at the Supreme Court over the last decade. As a result of the fact that Congress has basically taken itself off the field when it comes to Schoolhouse Rock-style legislating, we have had presidents of both parties increasingly resorting to unilateral action in the form of executive actions, regulations, and the like, in order to implement their preferred policies. And those policies have immediately been challenged by plaintiffs, typically in sympathetic courts of their choosing, and that has put the Supreme Court in the middle of basically every major issue in American life, and has done so sooner rather than later. And the court has therefore been wrestling not only with the biggest substantive issues of our time, but really fundamental questions concerning the allocation of power across the branches of government. And so much of the most significant work that the court has done in recent years has been in that area. And that is why, as Sarah and I were debating by text on our way up to Philadelphia, I disagree that tariffs was the most significant case this year. I agree with Fred that slaughter was the most significant case this year because it involved a question that I think will have long-lasting implications across administrations, namely the question of when the president has the power to remove members of independent agencies, multi-member commissions, and notwithstanding the fact that the Cook case came out the other way, that case is a little bit idiosyncratic for a number of reasons, and I don't think it will have broader significance beyond the Fed. So it's no accident that after our panel, there's going to be an entire panel on executive power. So I don't think I'll say anything more about that. I just want to say a couple of other things about the court more generally. The second thing that I want to say is that when you look at the court, particularly this term, I think one of the growing talking points about the court is that while we have a court with 6 Republican appointees and 3 Democratic appointees, the Republican appointees are decidedly not monolithic. And I'll give Sarah credit because I think Sarah, if she didn't coin the phrase, was certainly a champion of the notion that we have a 3-3-3 court with 3 justices who I think we would describe as more quote-unquote conservative in Justices Thomas, Alito, and Gorsuch, 3 justices on the left in the 3 Democratic appointees, Justices Sotomayor, Kagan, and Jackson, and 3 justices who I would describe as the pragmatic center of what is, to be sure, a relatively conservative court in the Chief Justice, Justice Kavanaugh, and Justice Barrett. I think what we have seen, particularly in the last term, is that those 3 justices in the middle of this court are themselves not monolithic. And in a number of the biggest cases this year, like the birthright citizenship case, there were significant differences among those 3. And those differences, by and large, given the camps on either side, really dictate the direction of the court today. So if you want to understand the court, you really have to dig into those nuanced differences among the justices because they really matter, particularly in the highest profile cases. And the third and last thing I want to say, which I'll say very briefly, is that I think that this was a very good year if you are a 1980s style member of the conservative legal movement. I think that if you were a Reaganite, a lawyer, you would find a lot to like in a lot of the decisions, particularly the decisions on the separation of powers. It was interesting that the issues on which
that we've seen across multiple terms, and in some ways, things John Roberts in particular has been working on for decades. And that's true about some of the separation of powers and presidential powers questions. These are things he's been long interested in. He's been developing them across cases across multiple terms, and we're seeing sort of a culmination of that. That's true of a lot of the administrative law and statutory interpretation questions in general. It's true of some of the First Amendment and voting rights questions as well that came up this term. So in some ways, what we're seeing is just a continuation of what we've seen in a lot of previous terms out of the court, and a continued movement of a set of relatively conservative justices advancing some constitutional ideas they've been very committed to for a very long time. And sometimes they wind up benefiting the Trump administration, sometimes not, but the long-term trajectory is one that they've been trying to work on over multiple terms. One longer-term feature of this court as well that's worth recognizing is how few constitutional cases the court heard this year and also tends to hear in general at this point compared to what the court used to do. And so there are some very high-profile, notable constitutional cases and decisions that came out this time, this particular term, as there have been in previous terms. But the fact is the court spends a lot more of its overall docket focused on statutory interpretation cases, administrative law cases, and the like, and a lot less on constitutional cases than had previously been the case. And so you don't see the court striking down laws as often, for example, as being unconstitutional, but also not upholding laws as being constitutionally valid compared to what the court had been doing before. This court is very focused on statutory interpretation, administrative law kinds of questions. And I think some of that's structural as well, as a feature of what the court's interested in, which is to say Congress isn't doing very much. And so what we're seeing is a lot of effort by presidential administrations, this administration, but also the previous administrations, to press the boundaries of pre-existing, often long-standing statutes, which then raise interesting questions about how much of those statutes actually support what those administrations are doing. They're often in a hurry to try to do them, so they're cutting some corners from an administrative law perspective. That's creating interesting and difficult procedural problems for the administrations as well. And the court then is confronted with trying to work out the details of those. And so you're seeing a lot of effort, given that Congress is sitting on the sidelines. You're seeing the court often being drawn into saying, well, is the president operating within the legal authorities he actually has, and is he doing it in the right kind of way? And so the court is spending a tremendous amount of time dealing with those kinds of issues in practice. Again, sometimes that winds up playing to the benefit of this particular administration, but not always. And so partially I think the Trump administration benefited this particular term from the fact that some of those kinds of cases that came before the court, with the tariff case being a notable exception, right? A very high profile, very important policy question from Trump, which he lost badly on, I think unsurprisingly won on this front, turned out to be exactly those areas where he's relying on old statutes, and they're old statutes that have given a lot of discretionary authority to the president. And I think unsurprisingly, the court upheld the administration's moves in how it exercised that discretion in those particular cases.
Well, thank you all for those initial thoughts that help us make some big picture sense of the term. One thread I'll pull out, or one tension, is that some of what I'm hearing is Congress is taking itself off the board, and what are the consequences of that? And another part of what I'm hearing is that the court is taking Congress off the board, and what are the consequences of that? And to the extent both are true, what are the consequences of that for
Title IX? And so what you see is a 6-3 along ideological lines decision, with the 6 conservative justices saying there is nothing in the Equal Protection Clause that prevents states from banning transgender participation in women's sports. What was more interesting to me is that the 3 dissenting justices weren't actually totally disagreeing with that point. They were saying that, in fact, the 14th Amendment did all the things that we now think it does. Why did we need a 19th Amendment about women's voting? So the Equal Protection Clause, clearly at the time that they ratified it from sort of that originalist perspective, was not about sex. But in the 150 years since then, we have read equal protection to mean similarly situated people, whatever that may be. And so you have race, where there's, well, this is part of the debate, right, over what exactly is that second founding of the United States? Is it starting over and ending the sense of slavery so that we can move forward with a colorblind constitution? Or was the purpose of the 14th Amendment to be remedial? Not to ignore slavery that had come before it, but to actually provide the government a means to solve the problems that it had caused by slavery. I think that is a interesting, vibrant debate over which people have good evidence on both sides, but that is the debate. So you get to sex, though, all of a sudden. The difference between 2 people with different skin colors is never going to be relevant to their job or performance or anything else, except with maybe, again, that remedial part of segregation. But when it comes to sex, there are sometimes differences that are meaningful and sometimes they're not. It doesn't matter whether you have a uterus for the purpose of becoming a lawyer, but it might matter if you have a uterus for the purpose of playing basketball. And so we have strict scrutiny for race, this idea that you must have a compelling interest and it must be narrowly tailored. But when it comes to sex, we have intermediate scrutiny, which I would argue is more like, you know, a fork in the road. Is it a basketball problem or is it a law degree problem? And then we send you off on these various paths. And we've never had a great way of dealing with sex in the Equal Protection Clause. This was the whole fight over the Equal Rights Amendment. And now part of the problem for those who are proponents of the Equal Rights Amendment is to be able to answer what exactly would the Equal Rights Amendment do, because we've read so much of it into the Equal Protection Clause, and how would any of this work anyway? So that's the transgender cases, which is all to say, this is basically, I mean, I said it was part one. It's actually probably more accurate to say it's part two, because we had part one last term about medical intervention. We will have part three, I predict, next term on the 21 states that allow transgender participation in women's sports. We've had several cases come up through the circuits already, including one out of the Second Circuit that was really fascinating to me, where they say that it does not violate Title IX for women because Title IX guarantees the right to play, but not the right to win, which would end women's sports. If you're like, you can try out for any team you want, good luck on the football team, like, that cannot be what Title IX meant. And so a case like that will end up being taken up by the court. Really quickly on the Second Amendment, this is a hot mess. We continue to have these Second Amendment cases where we have sort of this unique little jurisprudential petri dish, speaking of evolutionary biology, where we're evolving a totally different strain of originalism called text, history, and tradition. This case, the sort of fun one, I guess, was Hawaii's law, which said that you do not have a right to enter a Starbucks, even if you have a concealed carry permit, with your gun, unless Starbucks affirmatively puts up a sign that says, we welcome people with guns. So it's flipping that presumption. Most of the time you have to put up a sign that says, we do not allow people with guns. But in Hawaii, you'd have to have a sign that says, we do allow people with guns, and the Supreme Court struck down that law, 6-3 along ideological lines. We're gonna skip the law on this, but here's the part that I find interesting. On birthright citizenship, one of the key arguments from the administration, and to some extent from the justices who were in dissent, was illegal immigration wasn't a problem in 1868. So how can we possibly read the 14th Amendment with, about a problem that didn't exist? But when it comes to the Second Amendment, we didn't have assault weapons and we didn't have mass shootings, but that is not part of the analysis. And I think there's just a tension there that has not been resolved in text, history, and tradition, and in these Second Amendment cases. And next term, we have what I think will be sort of the culmination of the Second Amendment cases, although I don't think anyone's confused on how it's going to turn out. But this will be the direct challenge to state assault weapons bans. They're not going to survive. They're not happening. They're going down.
Thank you, Sarah. Fred.
So I volunteered to do the Fourth Amendment cases, which is a little bit like being the guy who shows up at the picnic and says, I want all the broccoli. Nobody else gets any broccoli. And so my colleagues were very happy to let me take these. But there are two great Fourth Amendment cases this term, both by Justice Kagan, which are interesting as a matter of criminal procedure. Are there any other criminal procedure jocks in the room, just so I know my audience? Nobody. Good. This is great. This is great. But actually, there's some interesting jurisprudential questions here hidden as well. So the first one is a case, oddly enough, called Case against Montana, which involves what has always been one of the real bright lines in criminal procedure, which is that the house, going into a house, is a separate sphere. You can't enter the house without probable cause. Probable cause to arrest, probable cause to search, and with a warrant. Somebody has to have examined that. Well, what happened in Case is that a young woman was on the phone with her probably boyfriend, but certainly somebody she was involved with, who is threatening to harm himself. And then she thinks she hears like a pop in the background. So she calls 911, and the police show up at the house, and they knock on the door. Nobody answers. They see beer cans around the house, and so they come in and they find him. He retreats finds a firearm. By the time this is all done, he has used that firearm, and he is charged with assault of a peace officer at that moment. His argument in his defense is they had no right to be there. They had no probable cause to think that there was a crime going on in the house, and therefore they had no right to come into the house. Now, under Montana law, up to the Montana Supreme Court, there's a community safety rule that allows that for articulable grounds, you can go into a home in those circumstances. And that's the posture in which this comes up to the Supreme Court. Justice Kagan writes an opinion for essentially a unanimous court, although we'll have to talk about how this plays out a little bit. But the first thing she says is that the Montana standard can't exactly be right, because the language sounded a lot like the reasonable suspicion standard. That's a standard for a Terry stop, a stop and frisk, as opposed to a full-blown seizure. So you can't enter a house just based on that. She says, but there's a category mistake here, she says. This is not an investigatory enter of the house. This is a safety enter of the house. And so the question goes back to, under what circumstances is a search reasonable? Don't forget the Fourth Amendment asks two questions. Is it a search? And if it's a search, is it reasonable? So she says the reasonableness question here is what is key, and that in this case, with the evidence that they had, not for an investigative entry of the house, but for a safety entry of the house, that this was reasonable under the Fourth Amendment. The Fourth Amendment, she says, does not require the state to stand by and let him harm himself, is the way Justice Kagan looks at this. Two separate opinions, just very quickly joining. One is Justice Sotomayor, who says, yes, but, or maybe yes, and. Let's just be aware of the fact that this sounds like a recipe that says, anytime you want to go into the house for purposes of trying to protect somebody, you go on into the house. And she said, let's remember what reasonableness really means, that in people with mental health issues who may or may not be harming themselves, police entering the house may not, in fact, be reasonable. It may not, in fact, be the best thing to do. Not true in this case, she says, so she joins in the opinion. But she wants to lay down a marker that before we say going forward that the police can always go into a house if they think something is going on there that may be dangerous, it's a much more focused, nuanced kind of inquiry that they have to do. The other opinion worth paying attention to, because it's going to come up again in our second case, is Justice Gorsuch, who says, we keep talking about all this reasonable expectation of privacy stuff. And this goes back to Katz, the case in 1967, which says that the Fourth Amendment doesn't protect places, it protects people. Katz was a case involving a wiretap, and the question of whether the wiretap was a violation of the Fourth Amendment. The last time the court had taken this up in the 1920s, in the Olmstead case, the court looked at it from a common law point of view, from a property point of view. It said, never went into anybody's house to put a wiretap in the house. The wiretaps were in the wires, literally, and never actually entered into the house. Therefore, the court in Olmstead said, no Fourth Amendment violation. A guy named Louis Brandeis, my personal hero, writes an amazing dissent in that case in which he says, no, the Fourth Amendment protects privacy, the right to be left alone. I've got to digress just for a second on a great Brandeis story with this.
Fred, we don't have time.
Oh, yes, this is a real quick one, and it's a good one.
Real quick.
I know, I'm looking at the clock, too. Brandeis wanted to put in this opinion, someday you'll be able to sit in your living room and watch things that are happening very far away. And a law clerk by the name of Henry Friendly says to him, Judge, you can't put things like that in the opinion. They're all going to think you're crazy. And imagine if he'd let him put it in there, we would have thought Brandeis was even more brilliant than he was. So Gorsuch says, put this expectation of privacy stuff from Katz aside. Let's look at this as a property notion. You have no right at common law not to have someone come into your house to rescue you. And he has a common law analysis that says that that's always been considered not an exception, as it were, to trespass, and therefore that's how he would view the Fourth Amendment. Now, the other case on the Fourth Amendment that came up, this term, Chaudhry against the United States, was a case that involved a geofence. Anybody out there got a cell phone? All of you? Yes. And you all have location history on your cell phone? And have you ever enabled it? Yes, that would also be all of you. Pay attention. A geofence is a tool used by law enforcement that, well, let's talk about what actually happened in the Chaudhry case. It was a bank robbery. And so the law enforcement goes to Google and says, give us all of the cell phones that were within 150 meters of the bank at the time this happened, at or about the time that this happened. Anonymized, not names, just the data at that point. They provide that to law enforcement, and law enforcement looks at it and evaluates it based on evidence they had from witnesses as to who was where, which direction they came from, and they limit it down now to 19 people. And they say, for those 19 people, now we want to know where they were for 2 hours, and not just within the geofence of 150 meters, any place they went. Based on that, they identify 3 people who may be suspects. Give us the names of those people. The question before the court is twofold. Is this a search? The answer to that is yes, in a Justice Kagan opinion. Is it a reasonable search? She says that one we don't have to answer. The only question for us right now is whether this is a search, and the answer is it is, and that it goes back on remand to say, was there probable cause? Was there articulable probable cause for each stage of this warrant going forward? Justice Gorsuch does not join that opinion. He writes separately, concurs in the result. Again now, he's saying it's not about expectation of privacy. Why was it a search, by the way, for Justice Kagan? Because we have a reasonable expectation of privacy in our location history on these gadgets. Gorsuch says, stop talking about reasonable expectation of privacy. I have a property right in this data, he says. So that gives you 6 votes in favor of saying that it is, in fact, a search, and on remand they'll have to figure out whether it's reasonable or not, given the actual workings of that warrant. Justice Alito writes Justice Alito writes a dissent.
We really got to move on.
What's that?
I'm so sorry, but we have to move on. I want to make sure Kannon and Keith have an opportunity to speak.
3 dissenters, and if you want to know more about them, see me at the cocktails.
Thank you so much, Fred. Kannon.
I think Chatri may actually be the most significant case that the court decided this year because it has very broad implications for the interaction between law enforcement and technology. But if the Fourth Amendment is the broccoli of Supreme Court jurisprudence, I think election law is probably the Brussels sprouts. I feel as if it's almost impolite to be talking about election law after 5 p.m., so I will accordingly be very brief. The case that perhaps got the most attention in this area was a case called Louisiana versus Calais, which involves a provision of the Voting Rights Act known as Section 2. It's a provision that prohibits the dilution of voting rights and has emerged as the primary statutory tool for rooting out racial discrimination in, among other things, redistricting. And in this case, by a 6-3 vote, the court essentially cut back on the scope of Section 2. And I think many observers thought that the court might go so far as to say that Section 2 was unconstitutional because it actually affirmatively mandated the consideration of race in, among other things, coming up with remedies for racial discrimination. But in the end, the court stopped short of doing that and essentially adopted a solution proposed by the Trump administration, which is essentially to narrow the scope of Section 2 by tightening up the requirements that a plaintiff has to satisfy to show racial discrimination. And before we get hopelessly down into the details, I think the best way to summarize it is to say that the court essentially said that plaintiffs have to show that it was racial discrimination and not a desire to have partisan political advantage that drove the redistricting. And that in cases where racial voting preferences and party preferences align, a plaintiff will essentially not be able to make out a valid Section 2 claim. And I think that will have the practical effect of greatly narrowing the scope of that provision. There were a couple of other somewhat unusual cases that I will summarize even more briefly. A case called Watson versus RNC, in which the court upheld state provisions that allow mail-in ballots to be counted after Election Day on the theory that as long as they're postmarked by Election Day, if they are received as much as 5 days later, they can still be counted. Some challengers argued that federal law precluded that because federal law mandates that ballots have to be received by Election Day. And the court, in a 5-4 decision with an interesting lineup, with the Chief Justice and Justice Barrett joining the court's Democratic appointees, upheld the law at issue, which was a Mississippi law, over the contrary position of the Trump administration. And then in a case called NRSC versus FEC, it's all acronyms in the election area, the court held that a longstanding provision of federal law that limits so-called coordinated expenditures by political parties on behalf of candidates for election violated the First Amendment. And the court has a remarkable edifice of case law around campaign finance restrictions. The basic gist of that law is that limitations on contributions are okay, limitations on expenditures are not. The court had previously upheld essentially the provisions at issue here under a decision known as Colorado 2, but the reasoning of that decision had been severely undercut by the court's turn towards a more First Amendment-friendly view of campaign finance regulation, and therefore a more skeptical view of restrictions on campaign activity. And the court essentially said in this case, as is its favorite approach to precedents it doesn't like, that to the extent Colorado 2 has any vitality, the court hereby overrules it. And that was a 6-3 decision along ideological lines.
Thank you so much, Kannon. Keith, take us away.
Okay, so very briefly, a free speech case and then birthright citizenship. So the free speech case is reflective of the fact that while we said that Congress isn't doing very much, state legislatures are still doing stuff. And so they generate controversial laws on some hot button issues, and among those was a statute that came out of Colorado regulating so-called conversion therapy. So in particular, a statute that said that therapists could not use talk therapy in order to try to change the sexual orientation or gender beliefs of their clients, although they could use talk therapy to reaffirm various beliefs. So it's okay to affirm that somebody's transgender, for example, but you can't talk someone out of being homosexual and try to convert them into being heterosexual under this statute. The court struck that down under First Amendment principles, so it deals with this sort of hot button policy question of conversion therapy, but there's also a sort of interesting doctrinal First Amendment issue, which is to what degree do standard free speech rules apply to so-called professional speech. So the kind of speech that professionals engage in while in the course of their occupations, is that sort of outside of the normal First Amendment free speech regime, even though those professional activities may involve talking. So the kinds of things therapists do, or lawyers do, or doctors do, et cetera, not the sort of hands-on stuff they do, but when they're just dealing with talking stuff. Is that outside the First Amendment free speech regime? For a very long time, it was regarded as outside. It's its own little petri dish of a different set of rules and regulations. The Roberts Court has been shifting towards saying, no, professional speech is covered by a lot of standard free speech rules. One thing that's interesting about this case is only Justice Jackson took the view that no, this is just pure conduct and can be regulated like any other kind of economic activity. First Amendment is irrelevant in this context. All the other justices think, in fact, the free speech rules apply in these kinds of contexts. Some disagreements about sort of quite what the scope of that might look like going forward. But this will have interesting implications for a range of cases that might emerge down the road involving quite a lot of different kinds of professions and occupations that talk a lot, and as a consequence might be regulated by the government and how they talk. So the other case that I want to talk about briefly is birthright citizenship. So Sarah says no one cares about birthright citizenship, and it will be a flash in the pan. I hope not, because I have a book I'm working on birthright citizenship. So, and moreover, I think that actually the fact that this was a 5-4 case is reflective of the fact that this is not about to go away. This is going to be a continuing political issue. There's clearly a massive political movement and growing political movement around these issues now, which the Trump administration reflects. And I think we're not buried by this case, and so we're likely to continue to see a variety of fighting about it over time, although exactly how the fighting is going to play out remains to be seen and what the permutations of that might look like. But as you may recall, President Trump issued an executive order that purported to deny children of undocumented aliens born in the United States and children of temporary visitors to the United States, denied them so-called birthright citizenship status, that they were not citizens by virtue of the citizenship clause of the 14th Amendment. Did this by executive order. This ran afoul potentially of two potential obstacles. One is Congress by statute had repeated the phrasing of the 14th Amendment citizenship clause. And so one kind of question is, does this run up against the statute? And the other kind of question is, does it run up against the Constitution itself? So various people thought that it was likely the court might take the exit ramp of just dealing with the statutory issue, ignoring the constitutional issue, say this is inconsistent with the statute, you can't do this through executive order, we'll kick the can down the road on the other questions. That's not what the court did. Instead, it reached for the constitutional issues, and a much narrower majority than most expected in a 5-4 case ruled that what was conventionally thought to be true is true in this case, which is that all those born within the United States and subject to American law are, by virtue of the citizenship clause of the Constitution, natural-born citizens of the United States. The striking, surprising part is that 4 of the justices disagreed with that, to varying degrees and on somewhat different kinds of theories, but a lot more support on the court than one might expect to think this can be restricted, at least along some dimensions. And the justices seem to divide some on how they might think about the temporary visitor issue as opposed to the undocumented alien issue. And so there's some space there among the justices. And I suspect there'll be room for future presidents and future Congresses to try to explore how much space there might actually be to work on this front.
Well, we just covered a lot of ground well and not a lot of time. That is not an easy thing to do. So please join me in thanking our panelists.
Please welcome David French, Gillian Metzger, Julian Mortensen, Ilya Soman, and Thomas Donnelly.
I'll get the end here if you want to go here.
So you're going to be on the end over here.
I'll go
and
here.
then
I'll go
I guess
here.
I'll go here.
I think that's right.
Okay with you.
That's great. Well, hello, friends. Great to see you. Thank you so much for coming out tonight. For those of you who do not know me, my name is Tom Donnelly. I am the lead scholar here at this wonderful institution. And in our second panel here, we have a massive topic of our own. We're going to be dealing with the Supreme Court and executive power, really focusing and drilling down on some of the issues that were teed up by the first panel: tariffs, the presidential removal power, the National Guard, immigration, if we'll get to that. So really massive topics. And I really can't think of a better trio of scholars to dig in here. Really 3 of the nation's experts on executive power. I'll give a quick intro to each, and then we're going to dig right in. So right here we have Ilya Soman. He's the professor of law at the George Mason University Antonin Scalia Law School and the B. Kenneth Simon Chair in Constitutional Studies at the Cato Institute. We have Gillian Metzger, who is the Harlan Fiske Stone Professor of Constitutional Law at Columbia Law School. And at the end, we have Julian Mortensen, who is the James G. Phillip Professor of Law at the University of Michigan School of Law. So please give a hearty National Constitution Center welcome to Ilya, Gillian, and Julian. And, I think the best way to tee up this discussion would just to get, as best we can, just really some initial, fairly brief, big picture thoughts about, what you're thinking about it when it comes to the Roberts Court and executive power coming out of the most recent term. Maybe starting with you, Ilya, and then we'll go down the row.
So I take it at this point, we're supposed to give a general overview, and later we'll talk about more specific cases. I think my general take on what's been going on with executive power is that on the one hand, the Supreme Court has been consolidating the executive's power within the executive branch, as with most notably the Swatter case and some others, though there's also the issue of how Swatter interacts with the Cook case, which I'm not sure I fully understand, but I'm sure we'll get to it later. On the other hand, the Supreme Court has been willing to constrain the executive's power in terms of its total scope. We see it in the tariff case, which I will talk about at greater length later, the National Guard case, whose significance, I think, has been underestimated, and some other cases as well. So in terms of the distribution of executive power within the executive branch, the Supreme Court has shown itself willing to consolidate more of that within the hands of one person, the president. On the other hand, when we look at the president's powers relative to Congress and also relative to the states and the like, the Supreme Court has, I think often correctly, been willing to push back, including on very major issues. Even the birthright citizenship case talked about in the previous panel, while it's primarily an individual rights case, there was also an aspect of whether the president could just change this by executive order. Turned out a majority of the Supreme Court said that he could not. So I think it is very important that the Supreme Court was willing to constrain this total scope of executive power in these ways, even though I don't always fully agree with the reasoning, and even though there are other aspects of the Supreme Court's work this term that I don't fully agree with. And in particular, I do think one area where it didn't push back as much as it should have was with respect to the area of immigration other than birthright citizenship, which I'm sure we may also get to later.
Excellent. Thank you, Ilya. Jillian.
Hi, everybody. So I am going to give you basically very close to exactly the same assessment. We talk about executive power in the aggregate, but the Roberts Court treats types of executive power differently. And one of the distinctions is between what you could say is more administrative power, the power to regulate, the powers to achieve substantive policies in the world, and then the other is the president's power over the administrative state and over administrative government. On the first one, you've seen the Roberts Court, and this goes beyond this term, this includes prior terms as well, pulling back on some of the substantive scope, particularly the substantive scope to regulate with things like the major questions doctrine and some other doctrines that they've done. But when it comes to the president's power over the administrative state, and I mean here not just the Slaughter case and the ability to remove certain officials at will, but also some cases that have come up on the shadow docket about funding, some cases about that have come up also about whether or not you can have reductions in force and personnel, just sort of a whole bunch of ways that the president controls the administrative state. There, they've been much more obliging of what President Trump has tried to do, and certainly beyond this, with Slaughter is the culmination of a longer-term project. So I think these are two different features of their jurisprudence. The question is, well, do they fit together well? And there's some tension between them, in part because one of the main arguments that is given often for why you need presidential control over the administrative state is because the president is elected and it gives us electoral accountability. The president needs that control to be able to implement the policies the president was elected on. Well, that's all fine and good, but in the meantime, you're cutting away the president's ability to actually impose or advance those policies by cutting back on substantive authority. So it seems like there's some tension there. I think that tension is resolvable, but it's partially resolvable by looking at the kind of ideological commitments among both. And one of the themes that links those two is these are both pulling back on regulatory power and controlling the administrative state, core ideas of the conservative legal movement. And I think that is the through line that animates the Roberts Court approach to executive power.
Excellent. Thank you, Jillian. And last but not least, Julian.
I'm just proud of myself for not answering when you said Julian.
It's very challenging.
That will happen at least once. So I would co-sign, I think, essentially everything that Ilya and Julian have said about the larger big picture moving parts of how to think about this term and also this term in longer arc. I liked also what Sarah said in the last panel about not thinking about this term as simply a term sitting alone, but rather as a term, as all terms are, and perhaps the last couple of terms more so than many, that are part of a story or a longer arc of time, a decade, 2 decades. And on my sort of big picture summary thoughts about executive power in particular, I'd flag what I think of as a really profound and persistent debate between 2 very different schools of thought about how constitutional separation of power should be addressed. On one hand, there's a perspective that takes executive, judicial, and legislative powers as silos, as mutually exclusive, and as something to be guarded, watched over, and decided upon by the Supreme Court. On the other side of this sort of large sort of, I almost said Hegelian, and now I did say Hegelian, this dialectical clash between 2 different ways of seeing separation of powers and thinking about separation of powers is a vision of the separation of powers in which what counts as executive power, what counts as legislative power, and what counts as judicial power are contextual, respond to current circumstances, and can be reframed often so that a thing, which is executive power in some dimensions, is also legislative power in other dimensions. And in particular, on this second vision, a vision of the separation of powers in which not Congress, but the legislative process is the entity that is advantaged, privileged, and given, if not final, certainly a very weighty say in deciding how to allocate the way our government works. In a constitution that requires the president to take care that the laws be faithfully executed, and which gives Congress not only the enumerated powers with specificity, but also to take care, the necessary and proper clause for organizing government in ways that Congress sees fit. And so on one hand, you have a vision of the separation of powers that, if you were to speak pejoratively, is wooden. If you were not to speak pejoratively, certainly is siloed and formalistic. On the other hand, you have a vision of the separation of powers that is pragmatic, responsive to evolving circumstances, and this is important, that privileges the legislative process and the law, which must go through bicameralism and presentment in resolving, or at least putting a very strong thumb on the scale of what kind of settlements ought to count as constitutional under the Constitution's separation of powers analysis. I'd say also that it's clear that for the foreseeable future, absent significant change in the court's membership, the party, so to speak, of the formalist, siloed, wooden approach to the separation of powers has not just won at the Supreme Court, but is in completely firm control and unlikely to be dislodged, as I said, unless there's changes in the Supreme Court. And I want to say they earned that. The movement that they represent, the school of thought that they represent, is a sustained, focused effort over decades to think about, articulate, and explore the implications of a way of thinking about the separation of powers. I feel about this turn, although I disagree with it, the same way that I feel about the challenge that was eventually successful to Roe versus Wade. These are movements that build up ideas, sell them, circulate them, build them, push them within the political parties. It's a thing that matters investing capital on. And from that perspective, I don't see the change, and it's been radical change, as on its face illegitimate. And I do think that people who are of the second school ought to think about prioritizing the political process, broadly speaking, as a way to start building, pushing, and consolidating around an alternative vision.
And I hope we keep a lot of these big picture thoughts in our mind for the rest of this discussion, where I'd like to really now drill down into a few of the big cases from this term on executive power. Maybe starting with you, Ilya, if you could begin with tariffs and learning resources versus Trump. Tee that up for us, and then I'd love to bring Jillian and Julian into that conversation.
Okay. So there was 170 pages of opinions generated by the Supreme Court in the learning resources case, second only to the birthright citizenship case in terms of the number of pages, but I'm going to try to distill it down to the basic issue at stake here, which was, can the president have the power to impose any tariffs he wants on any goods from any nation for as long as he wants, in any amount that he wants, as much as he pleases. And the Supreme Court in a 6-3 decision basically said that the answer was no. So I'll now drill down a little bit into the details, but I have to admit I'm not a completely objective observer of this case because I was involved in litigating it from beginning to end. The case actually originated in a blog post that I wrote when Trump first announced the tariffs under the International Emergency Economic Powers Act of 1977, which doesn't even mention the word tariffs and which had never been used to impose tariffs before in the previous 50 years. And into my blog post, I said somebody should challenge these tariffs under the major questions doctrine and under non-delegation. And also perhaps because this thing doesn't even allow for any tariffs at all because it doesn't mention those words. My thought was like somebody else would do the actual work of bringing the case and I would get to sit back and enjoy it and maybe I would bestir myself to write an amicus brief at some point, but through a complex series of events ended up helping to litigate it together with the Liberty Justice Center, a public interest law firm who invited me to join the case, and then together with other people as well. We won in the lower courts and eventually it got to the Supreme Court, which also decided in our favor. Our case was actually the VOS selections case, which went into lower courts, but it was combined with the learning resources case for procedural reasons. As a technical matter, our case was actually the one that won because theirs got dismissed for procedural reasons. They went to the wrong court, but given the naming conventions, they got to have their name on the case, and our clients lost out on that aspect of it. But what's more important than that is the issues in the case, and 6 justices in the majority, the 3 liberal justices and 3 conservative, Chief Justice Roberts, Justice Barrett, and Justice Gorsuch, they agreed on the simple notion that this statute, which had never been used to impose tariffs before and doesn't mention the word. It just doesn't authorize tariffs at all. But 3 justices in the majority, the 3 conservatives, also emphasized the issue of major questions. The major question doctrine says that when the executive claims a vast sweeping power that has been delegated to it by Congress, it has to be clear on the face of the statute. It can't just be inferred from vague language or the like. And here, this is probably the biggest major question that any of us had ever seen. It would have imposed something like $1.7 trillion in new taxes on American consumers over a period of 10 years. It would have given the United States the highest tariff schedule since the Smoot-Hawley tariff of the Great Depression, which severely exacerbated that depression, and it would have done massive damage to U.S. and world economies. So if this is not a major question, I honestly do not know what is, and those 3 justices laid out in somewhat more detail than I have just done why it's a major question and why it fits in with previous policies that were considered to be major questions, and I think that was correct. Justice Gorsuch, in his concurring opinion, also emphasizes the non-delegation doctrine, which the rest of the justices did not reach. This is the idea that there's at least some limit to Congress's ability to delegate legislative powers to the executive. Here, I think there's no doubt this is a congressional power. It's enumerated right there in Article 1 of the Constitution, which lays out the list of legislative powers. And exactly what is too much non-delegation, that is, or too much delegation, that is a disputable question. But if there's any limit whatsoever, the claim power to impose any tariffs you want at any time for any reason without limit, that has to be a breach of non-delegation. If anything is, I think Justice Gorsuch was right about that. There are lengthy dissenting opinions, one by Justice Kavanaugh, joined by Justice Alito, and one by Justice Thomas. The Kavanaugh opinion argues essentially that the statute, even though it doesn't mention tariffs, nonetheless still allows for them because it says there's a power to regulate importation, and so the power to, and tariffs have regulatory effect. If you impose a tariff, that reduces the amount of imports of that particular type. So I think the obvious problem with that is that the fact that something has regulatory effect does not mean that it is a regulation as opposed to a tariff or a tax. Otherwise, every time Congress authorizes the president or an administrative agency to regulate something, that would be a power to impose taxes as well. And otherwise, there would be no need for separate powers to regulate foreign commerce and powers to tax it, which are specifically separately enumerated in the Constitution. Then they also argue that the major questions in non-delegation doctrines don't apply or don't apply with much force because this is a so-called foreign affairs power. I think this is problematic as well because the Constitution doesn't distinguish between domestic and foreign powers. It distinguishes between legislative and executive powers, and this one is clearly legislative. Moreover, this is a massive tax on Americans, and therefore it's not purely foreign affairs, and there are various other problems with that distinction as well that I can talk about at length later if you really want to hear about it. Finally, there is a complex dissenting opinion by Justice Thomas where he basically would greatly narrow the scope of non-delegation and major questions in ways no other justice and no other previous precedent of the court would do. I can get into this later. For now, I'd merely say that when Justice Thomas goes off on its own, on his own, and nobody else joins him, sometimes he has really brilliant, profound insights. I think of that as the good Thomas, and sometimes he goes off in a really bad direction, which doesn't make much sense. That's the bad Thomas, and I think here we have bad Justice Thomas at work, and this is one of the reasons why nobody else was willing to join him in this particular reasoning. We all have our good days and bad days, even Supreme Court justices, and that is what happened here. So in terms of the broader significance of this case, some people like Sarah Isgur in the previous panel and David French, who is supposed to be with us, says this is a massive, historically important case. I don't know for sure, and I'm in some ways the wrong person to ask because I'm not completely objective about it, to put it mildly. We will see over time how important it actually is, but I will merely note that I think there is a broader significance in that the Supreme Court showed its willingness to constrain grants of tariff authority to the president, and especially to say that there should not be some kind of unlimited or virtually unlimited grant. All of the four opinions by the majority justices emphasize that point in various ways. This, I think, will have implications for future attempts to claim tariff powers by presidents, and it might have implications elsewhere as well. If nothing else, this helped lower all of our prices that we pay for all sorts of goods, and therefore had a massive potential effect on sort of the daily well-being of Americans. Much more can be said, including about the emergency powers aspects of this case, which were not actually addressed by the Supreme Court, but could be important later, and also about its broader implications for the rule of law. But for now, I'll stop, and we can turn the mic over to the other panelists.
Yeah, no, thank you, Ilya. And I'd love to bring Jillian and then Julian in. Just, with this tariffs case, we have a check on a major initiative of the Trump administration. As Ilya teaches us, the majority opinion is cross-ideological. You have some conservative justices, some more progressive justices in the majority. And if you look at the majority versus dissent, you see divisions within the more conservative justices, 3 in the majority, 3 dissenting. Maybe starting with you, Jillian, I'd love your thoughts, any general takeaways you have on tariffs, but how we should think about how significant this case is, specifically, and just as a broader signal. Anything else you think it could teach us about the Roberts Court as a whole and executive power?
Sure. It is a central initiative of the Trump administration that the court stopped. So it's significant in that term. In terms of how much it signals about the court's willingness to stand up to Trump, I think honestly it's hard to gather that much from one case. It's a big issue, but looking at the court as a whole, the question, I think we see that the court did resist the Trump administration on some aspects that were core to Trump's initiatives, but that there's a lot that they've actually been willing to allow go forward in maybe somewhat less visible ways. What I find interesting about this case doctrinally is we're seeing some divisions over the major questions doctrine that I think could be quite significant, and one of them has to do with how clear is clear. So the major questions doctrine is, requires this kind of clear authorization when exactly what counts as a major question, by the way, is a little bit of a matter of debate, but when you've got something that might be sort of this big grab of power, big political economic significance, unprecedented transformative features to it. So the doctrine sort of says you need clear authorization from Congress in order for an agency to act in that context. But you see the dissenting justices finding clear authorization without it being expressed in the text. And by the way, not only not expressed, but there are, 99 combinations of words that Kagan says, and one of them that's not there is tariffs, which is pretty significant. And so I thought the fact that they were willing to find it to be clearly authorized might be an approach they take for this case and not for others, but it signals a more fluidity about what counts as clear. And you have Justice Barrett also signaling that she might be more willing to find clear authorization than Justice Gorsuch is. Justice Gorsuch has had his sole concurrence, and he is the one who has always been most eager to develop non-delegation limits. And I think we saw again that he doesn't have the other justices on board for that, wherever they come down on major questions.
Excellent. So Jillian tees up major questions doctrine, which again is this idea that if it's a really big, important issue that Congress has to speak clearly in order for the executive branch to make policy on that dimension, and also some issues of non-delegation. Maybe turning to you, Julian, any additional thoughts here about the significance overall of this tariffs decision and, what we could learn from it?
I mean, you can tell at least a couple of different stories for how the key votes in the majority came out to where they are. Tariffs are, I think most economists agree, a pretty terrible idea, certainly used the way that the administration used them in the two major categories that were addressed, and with very, very significant, very, very bad economic consequences. And it's reductive, but it's not always wrong to be reductive. We've got a really significant, really bad policy that's going to raise the chances that the Supreme Court will shift, at least at the margins, and if there's room to play within the formal categories where it comes out. So that's one story. I don't know that I think that's the only story. Another story is, coming back to Jillian's observations in particular, a story about this statute, the International Economic Emergency Powers Act, being in some ways the granddaddy of all emergency powers statutes, and like the archetype of the thing that the formalists on the Supreme Court, or at least some of the formalists on the Supreme Court, are most concerned about, which is a blank check to the president to kind of do things that he or she thinks are useful, important, and necessary. And I will admit that when the case was filed, I just thought this is going to come to a good place, Ilya. I thought that Ilya was like Don Quixote tilting at windmills. I just like the IEPA, the International Economic Emergency Powers Act. You sort of think about it in the national security space as like, it lets the president do anything if the right kind of emergency is declared and there's a plausible exterior-facing aspect to it. It is a remarkably comprehensive statute with a very significant exception that Jillian has pointed out, the word tariffs. And the more I read of Ilya's argument, the more I read of some of the lower court opinions, I kind of came around to thinking, I think that the court got this one right, and I sort of started off thinking that the administration likely had the better of the argument. So I ended up persuaded by Ilya's argument, by the majority's argument, and as to how and why and what was motivating, it's harder to tell with any certainty, but certainly it didn't hurt in relation to the challenge, that the policy was really big, and I think most of the people who are big players in Washington think really stupid.
Excellent.
Our big achievement in the case was persuading Julian.
Yeah, that's right. That's right. I don't like delegations.
I know. That's why it's a big achievement.
And maybe coming back to you, Julian, we talked about tariffs here. Maybe we'll put the second big issue here on the table, which was the idea of the president's removal power. And the Roberts Court here decides two big cases, Trump v. Slaughter, Trump v. Cook. Maybe, try as best you can to place those interlocking issues on the table, and then I'd love to bring Jillian and Ilya in to talk about the significance of these two cases.
So super quickly, I don't know if it's possible to do it super quickly, but as quickly as I can. The Slaughter case with the Cook addendum sort of marks the culmination of a major project of the sort of formalist separation of powers movement's efforts when it comes to presidential administration and the ability of Congress to structure the American administrative state in ways that it sees appropriate in the following way. The case, the major case, the case that is most significant in terms of what it does to the doctrine, the Slaughter case, involves an effort, successful effort by President Trump to remove a member of the board of the Federal Trade Commission. She's protected by a for-cause standard. No, pardon me. The for-cause standard is the federal bank. She's protected by a classic, no quotes, for-cause standard, in which essentially you shouldn't be able to, under this standard as it's traditionally been interpreted, remove somebody who's protected by such a protection from office for merely policy reasons. And suffice it to say that the case that resolved this question in the New Deal opened a very wide space for Congress in determining how to structure new agencies, new regulatory mechanisms, to, in the mix and match grab bag of ways to structure the government, to include for-cause protections, including people at the top of agencies. And that gave rise to a category that doesn't have constitutional significance, but has very significant statutory and DC administrative law significance, between executive agencies, so-called, and independent agencies. And for many in the formalist school of thought about the separation of powers, the idea of the headless fourth branch of government that is the independent agency and the independent agencies was anathema, and Slaughter sort of is the coup de grace for any vestige of hope or expectation, with one important caveat, that there would still be room for tenure protections at the top level of any independent agencies. The theory basically is that the president has the executive power under the Constitution. If somebody else, certainly at a high enough level, has ways in which they can exercise authority over the execution of statutes without the president being able to say, I don't agree with that, do that differently, then the president doesn't have all of the executive power, and that violates the formalist separation of powers. The dissent's response to the majority's argument from this sort of broad theoretical perspective is that that has been one school of thought going back very, very early, indeed one of the earliest issues that Congress took up, but there's been a completely different school of thought that has accepted, entrenched, and created tenure protections at all levels of the executive branch, going back literally to the founding. This is a disputed issue. There's dozens of statutes over time that have created these kind of tenure protections, and how do we end up, Justice Sotomayor says in dissent, how do we end up prioritizing a beautiful theory of executive power over, essentially more than 200 years of experience in the actual liquidation of the Constitution and in the actual operation of the administrative state? That sort of is a big picture, the big picture resolution in in Slaughter, the FTC case. Cook says, notwithstanding that, because of special features of the bank, the federal bank, which are never actually explained, that is not subject to the holding of Slaughter, meaning that the Federal Bank of Reserves is the one entity in the federal government, it appears, that can now be headed by somebody or by several somebodies who have for-cause tenure protection. I think that most folks would agree that the court's explanation of why the Slaughter logic doesn't apply to the Federal Bank of Reserve situation is underbaked at best. There's a recitation of a long series of statutes in which independence was viewed as important for the bank. Kagan last time and Sotomayor this time in dissent in the Slaughter line of cases has a pretty long line of instances in which Congress has made that kind of determination with respect to other agencies that aren't banks. I don't think many people would defend the internal reasoning of the Cook Federal Bank of Reserve's exception on its face as a distinction from the overarching principle of Slaughter. But again, man, the Fed is really, really important, and there's going to be lots of really unhappy people and really, really bad consequences for the country if we don't have the sort of at least a semi-independent Federal Bank of Reserves, or so the wise people think. And that, I think, is as much as anything else an explanation for how the court comes out in Cook. And I have more thoughts on that, including an Edmund Burke quote if Jonathan Adler wants to hear it. But that's the story of the case.
And so with Slaughter, we get this broad presidential removal power of members of the executive branch. And as you say, Julian, with Cook, we get some insulation, some independence for the Fed. Maybe turning to you, Jillian, how much does a case like Slaughter sort of transform doctrine in this area, and how governance is actually going to work in the executive branch moving forward?
Yeah, I mean, I think Slaughter really is quite significant. It was predicted, but that shouldn't undermine our sense that it is transformative. There are dozens of independent agencies. This obviously will affect their leadership and how they operate. To be fair, Trump has already fired a lot of their leaders, so we're seeing this in real time, that it affects how they operate. One of the things or a couple of points about Slaughter that strike me on this, going back to something Julian said before about the two different approaches to separation of powers, and you really see in Slaughter this very formalist idea of presidential authority and executive, judicial, legislative, but you also see the court taking a very insistent form of exclusive presidential authority. Where the president has authority, it is the president's authority. Congress can't touch it. And you contrast this with an approach that says presidential legislative authority are actually often concurrent. Congress has, as Julian mentioned, the power to create offices, the power to structure the government. The president has the president's powers under Article 2 in terms of supervising. These are concurrent authorities, and therefore we have to come up with a test that sort of acknowledges the powers of both branches. And instead you have the court really focusing, and there's a line in Slaughter where the chief says, basically, if it is an executive power, it is therefore something Congress can't regulate. That is this exclusive power idea is really how this court approaches presidential and executive authority. And I think it's quite significantly different from how we did in the past and from how the Constitution sets it up, and I think it will be very significant. One further thought on significance is the language of Slaughter is very broad and broader than it needed to be. At issue, as you pointed out, was the leadership of the FTC. They are principal officers. You could have limited the decision to principal officers. Gorsuch refers to principal officers in his concurrence. The chief did not. The chief said instead the president needs to be able to remove at will his subordinates. Well, who are his subordinates? If you talk about the subordinates being anyone exercising executive power, well, that's not just principal officers. That's also inferior officers, and that's the civil service. That is where the battleground is. The Trump administration has a very strong agenda of trying to get rid of civil service protections and career protections, and that is not just limited to independent agencies. These are the employees across the federal government. And Slaughter leaves open the possibility, and certainly the logic of this unitary executive theory would suggest that the president might have to have the power to fire all of them. There are certainly ways you can distinguish among inferior officers and employees and principal officers. There's precedent you can distinguish. The point is the court didn't do that in Slaughter. And the fact that it didn't do it in Slaughter means that we know what kinds of litigation there's going to be coming. There's already cases involving challenges where people who had career cause protection against removal were fired and are challenging that. So we're going to see this issue come up. And what would really, really, really be transformative is if the Roberts Court were to hold that, in fact, it's not just the principal officers who can't have removal protection, but it's all the way down. That would really, really be a very big deal.
And Ilya, thoughts about Slaughter and Cook?
Yeah, so I have one internal thought about the logic of these two cases and then a couple brief broader thoughts about how these cases relate to other things. The internal thought is that I at least do not get how Slaughter can be reconciled with Cook, and therefore it is not clear to me sort of what will be the approach to other agencies in the future. There are a number of ways you can try to reconcile this. You can try to say, as the Supreme Court said in Cook, well, there's a long tradition of the Fed being independent, or of the predecessors of the Fed going back to the First National Bank of the US being independent. But of course, if it's just a matter of tradition, there's a tradition of other independent agencies being, to some extent at least, independent for over 100 years. Another possibility is that the Fed wasn't really exercising executive power, at least not with respect to its power to issue currency, that's not really an executive power. But if you go that route, you can make similar arguments for a lot of other agencies as well. Moreover, as Justice Gorsuch, I think, quite correctly points out in his concurring opinion, a lot of seemingly independent agencies exercise a sort of mix of powers. They do adjudication, for example, as well as issuing regulations and enforcing them. If there's an agency that exercises some powers that may be seen as non-executive, then maybe it's more like the Fed. So I think the interrelationship between these two cases is still at the very least somewhat unclear. And by the way, I do not accept the argument which says, well, it's just a matter of which one has a corporate interest behind it and which one does not. Because if you look at a lot of regulatory issues, including those involving the FTC, there are actually corporate interests on both sides of it. Some corporations want more regulation, some want less. And of course, where one administration of one party can use it to have less regulation, the other can use it in the future to have more. There's a broader issue here, though, maybe two of them. One is, as Justice Gorsuch points out also in his concurring opinion, if the executive has largely unconstrained power to remove subordinates and impose its will on them, that makes it all the more important to constrain executive power through major questions and non-delegation to make sure the executive isn't grabbing too much power overall. Another is a broader issue. I think there's a kind of possible selective originalism here in that a lot of the regulatory power that is wielded by these agencies is power over issues that were never supposed to be within the scope of federal authority to begin with. For example, drug prohibition. It once took a constitutional amendment to impose nationwide alcohol prohibition. We later forcibly repealed that amendment. Drug prohibition should be no different. And I can say many similar things about a vast sweep of other federal powers. If we have agencies that are wielding powers that are not supposed to be part of the federal government's authority generally, then why is it that we should require that just one person gets to wield all that power as opposed to Congress being able to divide it up? And I think that's an issue also not well addressed in these cases.
And so there we have tariffs, we have presidential removal. Now, I'll turn to Jillian here, and maybe as we get to the closing minutes here of our discussion, think a bit about the interim / emergency / shadow docket, whatever we want to call it. Maybe talk a little bit about the importance of that docket here for the second Trump administration. This National Guard case, Trump v. Illinois, is sort of the highest profile one. But if you want to tee that up and anything else you want to explore on that front.
Sure, happy to. Yeah, so the emergency docket / interim / shadow docket, it comes by many names. And for our purposes here, what we're really talking about are applications overwhelmingly by the federal government for stays of injunctions, preliminary injunctions often, that have been issued against Trump administration initiatives by lower courts. And the Trump administration has made an extremely large number of such applications, and they have been granted at a very high rate. So there have been 28 applications. The federal government has succeeded in part or whole in 21 of them and lost in 7. For a success rate of 75%, that's very high. These involve a number of different kinds of issues. I've mentioned some, but there have been a lot of issues about funding, grant cancellations, personnel moves. There were some immigration cases as well. Cook was actually a case that was on the emergency docket. So sometimes, usually these aren't fully briefed or argued. Sometimes the court will put them down for argument. Sometimes they will grant a stay, but then take cert before judgment in the case. The cases in this area tend to be very contentious in part because you don't get a lengthy reasoned opinion at all. You get very short analysis. Sometimes you don't get, often there is no explanation. It makes it very hard for lower courts to figure out how do you read what it is that the Supreme Court is doing. They've been contentious, a number of them, at least 10 were divided 6-3 along the traditional ideological grounds of this court. And the dissenters and the liberal justices have been complaining quite forcefully about these decisions. So overall, this is an area in which the government has been winning and winning big, is one thing I want to make clear. That said, there's one important case, the National Guard case, where the government lost. And this arises from President Trump's efforts to federalize the National Guard over the objections of the state governors where those National Guards were, to use them to protect immigration officials and be involved in sort of protecting immigration enforcement. And Trump invoked authority under a statute that says basically if there's a rebellion or insurrection, or when the president determines that the regular forces are not able to execute the laws. And the issue that had happened, that had been the focus of this case in the lower courts and in some other cases involving challenges to the National Guard, was really whether or not there were grounds, factual grounds, any supportable basis on which to conclude that the law enforcement, ordinary law enforcement, weren't enough to protect immigration officials so that they could perform their function. And a number of judges concluded on very lengthy sort of assessments of the factual evidence, including famously in Portland, a Trump-appointed judge, that in fact there just wasn't the evidence to support this determination. This is the kind of typical area, talk about IEPA being an area of broad presidential power. This is a kind of presidential determination that ordinarily courts defer to extremely, and so the fact that so many judges said there's not evidence there and this is pretext, the National Guard was often brought out to blue cities and blue states, is really significant. But it gets to the Supreme Court, and the Supreme Court holds that the term regular forces is not referring to ordinary law enforcement, but is referring to the military. And that if you want to be able to show that the military are unable to execute the laws, then what you need to show is that there's some kind of statutory or constitutional authority for the military to be involved in domestic law enforcement at all, because under the Posse Comitatus Act, there needs to be express authorization for the military to do that. And they said the Trump administration hadn't identified any such authority, and that the president's traditional protective power didn't apply here because this wasn't, didn't count as executing the laws as that power had been understood. The vote was 6-3. This is, again, not a lengthy explanation at all. It's very short, remarkably short for such a dramatic kind of potential pullback on presidential power. And you had Justice Kavanaugh not willing to go quite as far as the majority did, so he concurred, but he also said, I would give the chance more for I wouldn't go as far in terms of determining what you have to show in order to bring out and federalize the National Guard. And then you had 3 justices who were dissenting, Alito, Thomas, and Gorsuch. And this is a potentially very significant decision. It sort of is interesting in that one of the things it leaves open is the possibility that the president might invoke the Insurrection Act, which would be a very dramatic move. And the Insurrection Act is one of these statutes that is too broadly worded and authorizes the president to call out the military and the National Guard in terms of addressing certain kinds of conditions, domestic violence, insurrection, rebellion. But then the key question would be, is there a factual basis to conclude that those conditions exist, and what is the standard of review? Part of what the court was doing by deciding the cases on the grounds that it did was avoiding this whole question of how do they review factual determinations by the president.
Excellent. And we have just a few moments left here. I'd love to hear any closing thoughts, either on the National Guard, interim emergency shadow docket, or more broadly here from Julian and then Ilya. So first you, Julian.
On the National Guard case, one consistent line of criticism of what the courts did, what the Supreme Court did in that case was, and you see it in lots of instances where there's high-profile, high-stakes national security questions, that the courts have no business interfering with the president's exercise of either emergency powers or military authority. And in an age of ascendant or ascended originalism, I think it's really important to recognize how at odds that is with the practice of the first, second Congress and of George Washington's practice in office. The Whiskey Rebellion was a cataclysmic challenge for the federal government. Pretty much the entire Ohio Valley was aflame, an army of 8,000 people marching through Pittsburgh. The challenge to the capacity of the federal government to govern, to be a government, to be the new Union of the United States was directly at issue. There was a statute. That statute permitted Washington to call out the militia under certain defined circumstances. Procedural prerequisites, he complied with them. This is the crucial part. He had to find and then show that combinations too powerful to be resisted or something like that were preventing the execution of the laws of the United States. And he had to get a certification to that effect from a Supreme Court justice or a lower court justice. And not only did he do that, when the lower court, no, actually Supreme Court justice sitting as a trial court told him the evidence wasn't good enough, that he needed to bring back more detail and have it certified in a way that was appropriate for a court of law, he went, got the certifications about Western Pennsylvania being aflame, came back, and then got the certification. There was not a whisper of a question of a doubt that that was an appropriate role for a court to be playing, and it's very reminiscent of the lead that the Washington administration was not just prepared, but eager to give to the Supreme Court in the Neutrality Proclamation, seeking its guidance on a range of important foreign policy issues before it acted. And so it's really, really important to recognize the ahistoricity of claiming that courts don't have a role in supervising and checking the president, including in areas involving the use of military force and emergency authorities, although of course the tradition has been to be deferential in the face of at least marginally plausible factual claims undergirding the legal assertions of the administration.
Excellent. And final word to you, Ilya?
So I would just say that in the National Guard case and in the IEPA tariff case and in some others, although I think the court got those right, they avoided in each of those cases the issue of reviewing the president's factual determinations or whether there really was a sufficient emergency to justify the use of these extraordinary emergency powers. But sooner or later, I think issues like this will come before the court. And I would argue that when you have a power that's only supposed to be exercised in the event of an extraordinary emergency, like an insurrection or a combination that prevents the execution of the laws, like with the National Guard statute or with IEPA, there must be an unusual and extraordinary threat to American national security or to the economy or foreign policy, or in the Alien Enemies Act litigation is going on, there has to be an invasion or a declared war or a quote-unquote predatory incursion on U.S. territory. In each of these cases, I think courts should be able to review those, because if they cannot, if we just have to take the president's word for it, then an extraordinary emergency power that can only be used in extreme circumstances becomes a blank check that the president can use anytime he wants, which is a menace to the rule of law, to civil liberties, and to the original structure of separation of powers. And you get absurdities like what happened in the Alien Enemies Act oral argument before the Fifth Circuit a few months ago, where one of the judges asked the administration lawyer, well, would we have to defer if the president said that the British invasion of rock stars is the kind of invasion that justifies using the Alien Enemies Act? And the Justice Department lawyer had to say, yes, it does. You would have to defer in that case. And when you're saying absurdities like that, that's a sign that the position of deference on these kinds of issues has gone badly wrong and should be rejected.
Excellent. Ilya, Julian, thank you so much.
Good evening, everyone. I'm Julie Silverbrook. I'm the Chief Content and Learning Officer here at the National Constitution Center, and I am really pleased to be with all of you to have a conversation about civil discourse and the U.S. Supreme Court. We have a wonderful panel with us to have this conversation. We have Catherine Mims-Crocker here from Cornell Law School. Next to her is Jonathan Adler from William & Mary Law School. Greg Garr of Latham & Watkins, who's one of the nation's leading Supreme Court advocates, and Howard Wasserman of Florida International University College of Law. I want to begin with you, Catherine, and talk a little bit about some of the fairly pointed exchanges between the justices during this term. When does forceful judicial writing sharpen constitutional debate? And I think it does. It's certainly more interesting to read. But when does that really start to begin to undermine the norms of collegiality or the perception that the court is more collegial than the political branches of government, for example?
Thank you. Thank you, Julie, and the National Constitution Center, Neil, and the Texas A&M Center on the Structural Constitution for having all of us. I'm excited to talk about civil discourse today. And I think that this term has been an example, a good example of sharp disagreements among the justices. As you say, I think last term was as well. CASA, the universal injunction case really comes to mind. I think, to me, the recent disagreements among the justices in their written opinions don't necessarily stand out for being sharper in tone than previous years. I think there's a different cast of characters now. And so, Justice Scalia, for instance, was famous for having sort of sharp rebukes of his colleagues in dissent, sometimes having sharp elbows in dissent. And now we often see Justice Jackson playing that role. But I think there's a difference in, I don't have the numbers in front of me, but what strikes me is that we're seeing so many separate opinions, that there are often very long, that they can be much longer than the majority opinions. And so while I think it's great that the justices are sort of mixing it up in their writings and that they're disagreeing with each other in a respectful and reasoned way in the writings, I think that sometimes the sort of length and complexity of the opinions can decrease the sort of sharpening of judicial reasoning that we could perhaps see from shorter, more to-the-point opinions, if that makes sense. I think that separate from the opinions, that what sort of Supreme Court watchers often debate is whether the justices are getting along and engaging in civil discourse as much behind the scenes. I think maybe we've seen some evidence recently that personalities can be kind of fraying against each other on the Supreme Court. I could think of 3 examples from this term really quick. One I actually think is a model of civil discourse outside of the court, and that's when Justice Jackson and Justice Kavanaugh had sort of a formal public debate at a judicial event on the shadow docket. We've also seen a situation this term, for instance, where Justice Sotomayor criticized Justice Kavanaugh in somewhat personal terms in a public appearance, but then apologized, which I think was also a model of, showing an allegiance to collegiality that the court has long done. Same with, recently there was a little sort of dust up on the bench between Justice Sotomayor and Justice Alito when he responded to her dissent being read from the bench in a way that was unusual. And then again, the court's public information office came out and said there was a misunderstanding between the two, was trying to sort of smooth things over. So I think it shows that the justices are still trying to adhere to a culture of collegiality, but I think there's questions about to what extent that might be affecting the way that the court gets along these days.
I want to have Howard weigh in on this as well. If you think that, as Catherine says, we're within a standard deviation or two of where the court has historically been, or if you think that the collegiality both on the bench and off the bench is starting to deteriorate in a meaningful way.
We're not that far from Justice Scalia talking about putting his head in a bag. So we haven't had exchanges quite like that this term. I think there's 3 things that might make this different. One is I think we have a very stable 6-3 court at least in most politically salient cases. And so you've got the same 3 justices in dissent a substantial amount of time. In particular, it's Sotomayor and Jackson, even more than Kagan. So I think a certain amount of of fatigue has set in. I think a certain amount of frustration has set in on both sides of the equation is one. And two, when the language gets pointed, if you watch what it's about, it's usually less about substantive disagreement with the ultimate issue in the case, and it's more about process. Whether each side is or is not following the process, and if one side or the other is being inconsistent or hypocritical. So on the shadow docket, when should the court intervene? When should the court explain why it's intervening? When should the court overrule precedent? When is it okay to engage in pure error correction through a summary reversal? And so a lot of the back and forth is, why did you pick this case to write about? Why did you intervene in this case? And that's where the elbows get a little bit sharp. And then the third thing is they're talking to each other, and I think Catherine alluded to this, they're talking to each other, and they're talking to the public off the bench a lot more than they used to. And maybe how they talk in those forums is a little different than how they talk in their opinions.
Greg, are you seeing any, sort of sharper elbows during oral argument?
I don't think so. I mean, the oral argument is the opportunity where the justices get to hear from each other about cases. And, often the most important debated oral argument is among the justices themselves and not between the advocate and the justices. And they're always pointed, but the nature of oral argument has changed a lot in the last decade. If you go back to a decade or so, arguments were an hour long, and it really was sort of a feeding frenzy where you could sort of picture a cloud of dust sort of following the issue as the justices debated it, all sort of, as one collaborative process. And today, in the post-COVID era, arguments are much longer. They include a period where justices get to ask sort of seriatim questioning, and that has changed the nature of the argument. I think is caused the court to become more siloed in its questioning, and I think that has, in some instances, brought out sort of more extreme efforts to sort of take apart an issue, and so I think that has changed the nature of the debate at oral argument a little bit.
Jonathan, I want to let you weigh in on this question, but I also want to talk a little bit about the commentary outside of the court, where I do think pretty notably we've seen the commentary become more personal, more immediate, more audience-driven, less analytical, and I want to talk a little bit about what is driving that shift in commentary.
Sure. So on the first point, I would just say some observations about things that might have changed that might make the court be generating conflict in the court. One is with the increase of the interim docket, shadow docket, whatever we want to call it, the justices are working year-round with each other in a way that they historically haven't, and often under time pressures when things come up in the interim docket. And whereas traditionally, the big cases come out at the end of June, and those are the cases that people are paying a lot of attention to, the cases maybe some of the justices are most invested in, and there's a cooling off period. And some folks have suggested that actually historically has helped the court maintain a collegial relationship. And so there is at least a question, is if over the summer they're having to do a lot of stuff through memos and a lot of back and forth under very tight time considerations where they don't have the same time to reflect on the substance of the cases and to really think them through and to really weigh the arguments and don't have that cooling off period, does that lead to a greater fraying and a greater degree of friction? And then something that added to that, there is reason to think that some of the exchange of ideas and arguments within the court may have been lessened due to concern about security of information. So not both the Dobbs leak and the leak of documents related to the Clean Power Plan litigation. There is some reason to believe that has lessened the amount of back and forth, lessened the amount of that's been being put on paper and shared with other chambers, which could also lead to greater fraying because the degree of communication across chambers would be lessened. And so those are two things that I would at least think we want to pay attention to. On your other point, I do think that the nature of political discourse today and its very polarized or tribal nature, we certainly see reflected in discourse about the court. There are a lot of factors that I think contribute to that. You know, when a decision comes out, we want to know what it said right away. We want to know who won. We want to know what the zingers are. And those are pressures that really, you know, press against the way the court really does its best work. Right? We heard on earlier panels about opinions in cases where the justices combined wrote over 150 pages. That's not condensable to, oh, who won, who lost, and what's the great one line that we can put in a tweet.
And also tell us that 5 minutes after the opinion is released.
Exactly, right? So, and so the way we want to process that information, and especially on social media, just doesn't fit well with the way the court does its work. And I think that affects the way that folks talk about the court. I think a lot of the commentary about the court is very much becoming more polarized, just like a lot of other political discourse is, right? You know, you can listen to your conservative podcast or your liberal podcast, and you can listen to the podcast that's going to make fun of the justices on one side or make fun of the justices on the other. And that, as opposed to those sorts of forums being places where folks who have read the opinions, digested the opinions, thought about the opinions, can try and wrestle with them and unpack them. And I think some of us in academia actually kind of see the discourse moving in that way, and it kind of creates pressure because that's the way a lot of students are learning about cases. That's the way, you know, folks that you otherwise engage with are learning about cases, and it really drains a lot of the substance of what's going on into, oh, well, did the Trump administration win, or did a corporation win, or did the criminal defendant win? Whereas as a legal matter, what's really actually more important is, well, what was the decision, what was the rule that the court based its decision on, because that's what's going to matter for other cases, and that tends to get lost.
To what extent is social media a driver of this? There was a time when X used to be called Twitter, where people used to look forward to Supreme Court and legal commentary on social media. Maybe people still do. Jonathan, I know you're still really active there, but I don't personally look forward to analysis on social media any longer, because I do think that space has shifted as a place where really intentional and thoughtful analysis is happening. And so, Greg, just to get a sense of the ways in which social media has impacted commentary about the court.
I definitely agree with Jonathan that, you know, it has polarized the issues more. People want to jump in. If you get, the more extreme you are, the more clicks you're going to get from either side. You have less time to analyze the opinions, and so you're really trying to, you know, pick that one zinger. And, you know, 200-page Supreme Court opinion like the birthright citizenship opinion that we got a week or so ago, it doesn't really lend itself to that kind of analysis. So I think it has made things worse. You know, the other thing that Jonathan mentioned was the podcast that exists. And that's been sort of, you know, wonderful in some ways. It's a much more accessible way to get information about the court. And there you do have people who have a little bit more time to analyze things. But it's also, like everything else in our world, very easy to get siloed and just sort of go to the place where it tends to reaffirm your views and not to look at the court more broadly. And so that might have sort of also caused people to sort of like entrench into their corners.
I talk a little bit about some of the commentary that talks about the justices, I think, in sort of personal terms. And then, Greg, I want to turn to you about the relationship between that and the rising security threats against justices, including an assassination attempt on Justice Kavanaugh. So, Catherine, maybe to start with you, just on the personal nature that, and I do think that this matters, right? Is that people talk about the Chief Justice in ways that are critical of him as a person, in more than criticizing the opinion, right? As a jurist, as a thinker, as a institutionalist, right? And so I think that that's pretty significant in shifting the way that people think about commenting on the court and the way that people think about the court itself.
Yeah, absolutely. I think that when we're talking about sort of more modern forms of media, Twitter, X, podcasts, going back a little bit further to blogs, that they really show sort of the best and worst of commentary on the Supreme Court. I think, as Greg alluded to, they've democratized the ability to analyze and discuss the Supreme Court, to sort of digest the opinions in the town square in a way that wasn't possible before. But at the same time, there is this modern attention economy, right, that prioritizes quick sound bites, witty hot takes, and these kinds of things. And so there are some podcasts, for instance, some scholars who are interacting on social media who do a wonderful job analyzing opinions and interacting with people in a way that you just couldn't get before when you had a handful of Supreme Court reporters at newspapers, scholars who were able to publish in the New York Times, op-eds, things like that. At the same time, you do have some people who are out there sort of, as you mentioned, Julie, criticizing the justices in personal terms. I think that when we're talking about civil discourse, it's important to be able to criticize the Supreme Court, but we as scholars, we as citizens can model doing that by engaging with the reasoning of the court's opinions as opposed to criticizing justices in sort of an ad hominem way or attributing motives to them that may or may not be correct. And that's where you can really sort of shade into the possibility of physical violence against justices in ways that we've seen threatened in recent times. And that I think podcasts especially, but also social media and these more modern forms of media can contribute to, but we can also work to push back on those.
Actually, by and large, I think the scholarly community does a pretty good job of civil discourse. I want to talk a little bit about public discourse, which a lot of times kind of blurs into this person is a bad person. They don't care about the Constitution. They don't care about democracy, right? And talking in those personal terms, I do think contributes, one, to a lack of overall sort of public confidence in the court as an institution, and then also I think lends itself to the kinds of security threats that you're talking about. So Greg, I want to get into that a little bit more with you.
Yeah, I think that one thing is unique and uniquely dangerous in our age is attacks on the legitimacy of the court as an institution and the legitimacy of individual justices. And I think that we've really seen this ramp up more recently, particularly in the wake of Justice Scalia's death and the confirmation battle that ultimately led to Congress not filling his seat, and then President Trump in his first term filling it, which was, a great political disappointment to many, but ramped up attacks on legitimacy of the court to the point we talk about adding justices, reforming the court as an institution, and also attacks on individual justices not being legitimate because they were confirmed in a particular way or by a particular vote. And I think that is, very dangerous. I think that has brought out the worst in some people and has increased some of the security attacks on the court. I mean, one thing I wanted to say just more generally, though, is attacks in the court are not new. We've had them throughout our history. One time, Philadelphia and Thomas Jefferson, he didn't say this in a tweet, but he was very critical of the court. One quote that I came across, he was as part of a review of a constitutional book, he wrote that he described the court as a subtle corps of sappers and miners constantly working to undermine the foundation of our confederated republic. So, in one sense, what we're seeing now, attacks on the court, is not new, but they do seem like they've ramped up in a way that is, not particularly good for the country.
I want to bring Howard in on this. So criticism of the court, of Congress, of the president, this is all sort of healthy, right? It's healthy to have skepticism. That's a part of being in a constitutional democracy. How do we distinguish between a healthy skepticism of the court and rhetoric that delegitimizes or even personalizes in a way that's personally threatening to the justices and to the court?
I mean, we can use the First Amendment as the standard, and if it's not a true threat, and if it's not incitement to unlawful conduct or incitement to unlawful activity, then it's fair game. I think we can tie in a lot of the different threads here. Excuse me. One of them is the democratization, because as Greg pointed out, we've had attacks on the court's legitimacy going back to Jefferson and all the way through. What's changed is more people are talking. There are more outlets for more people to talk about the court, to get information about the court, and then to talk about it in real time. It's not going to be as intellectual and academic and thoughtful a discourse, perhaps. But I don't think we should sort of change the rules of the game of what's fair game in the public discourse, because there are more voices who are able to yell more loudly and in a way that we might not like. I also think that questioning the legitimacy of the court is a legitimate form of discourse. If you look at the court, hopefully in a thoughtful way, and you conclude that these are partisan actors acting in a partisan way, then I think it's fair game to say that and to make that argument and to argue for changes like expanding the size of the court to reflect that. Now, we hope that the reason for it is more thoughtful than this case came out a way I don't like, and therefore the court is illegitimate, but we hope it's more thoughtful than that. But I think questioning the legitimacy is a perfectly fine form of discourse, particularly if we think about free speech as the engine of social change and of political change, and expanding the size of the court or changing the court's jurisdiction or whatever is a legitimate form of political debate and of political change.
I want to bring Jonathan in on this. So how do we ensure that that kind of analysis is thoughtful in an environment that invites snap judgments over intentional thought?
Yeah, there's a lot there. Let me first say, I think, because I agree with Howard on some points and I disagree with him on some others. I mean, certainly as a First Amendment matter, one has the right to say all these things. But I think we can all agree that there is a wide swath of First Amendment protected speech that in most circumstances is regrettable or imprudent or unwise, right? There are all sorts of nasty, awful things I could say right now that would be First Amendment protected, that many would find very offensive, and it would not be a good thing for me to do that. Similarly, I think people that have a certain degree of authority and knowledge about the court should recognize that when they speak about the court, the influence of what they say might have more persuasive power than others. And even though there are things that they are perfectly free to say as a First Amendment matter, they should think about what it is they say about the court, how it is they say about it, right? So as someone who is an academic that studies the court and studies the law, I think when I talk about court cases, I have an obligation to characterize those decisions and the actions of the court fairly, accurately, not try and put out the tweet that's going to get me the most likes or retweets or whatever else, or get me monetized or something, but say things that I'm willing to stand behind that I think are accurate. And I do think that increasingly political figures and others don't spend enough time thinking about that. And while a lot of the things that people say, including challenges to the court's legitimacy, couldn't be prosecuted as true threats, it is true that we have increasing threats to judges and justices, right? There have been at least 3 intercepted attempts on the current court, not just the Kavanaugh attempt. There was the Red Mass incident, and there was the swatting of Justice Barrett. We have had attacks on lower court justices. There are at least 2 people that have been convicted of death threats against Judge Kaczmarek, who issued some very controversial and, in my view, quite wrong decisions related to Mifepristo. But that should not be the sort of thing that leads people to make threats to his or his family's physical safety. And I think in our current political environment, we have to recognize that if those of us that hopefully can speak with some authority about the court, do say the sorts of things that can be understood as challenges to the legitimacy of courts, We have to recognize that that sort of language and discourse may create a permission structure for things like government officials disregarding court decisions and disregarding court orders and, and leaving it to the political process to sort out what happens with that. So that doesn't mean we can't say those things, but I think we recognize that those of us that hopefully are not just random people on social media saying random things about things that upset us, think carefully about why we characterize things the way we do and when we do that. Last thing I'll just say on this, that doesn't mean don't be critical. That doesn't mean don't call out things that are problematic. That doesn't mean refrain from pointing out that even apart from court expansion, there are whole lots of things that Congress has the authority to do that affect the jurisdiction and authority of the courts to do various things, right? Should you have to go to the Court of Claims before you go to a district court? Should the Supreme Court be allowed to hear certain sorts of cases? Should the Supreme Court be required to hear certain sorts of cases? Something that through most of the nation's history, the bulk of the court's docket was not a docket that it chose. It was a docket that was imposed upon it, right? There are all sorts of things that should be more part of our discourse about how we think about the role of our courts that aren't about is it legitimate or not, but are really about is the judiciary performing the function that we want it to perform and need to perform at our current political moment, and how do we think about going forward, what that role should be.
You just said something really important, which is that civil discourse doesn't mean that we agree with everything and that we can't be critical. I think what we see in some instances, particularly on social media, and particularly at the end of the term, right, when we get all of the big decisions, and Catherine, I want to bring you in on this, because the Supreme Court doesn't actually have to release decisions that way, right up until Independence Week, which for those of us who were celebrating, we're a little nervous about how that might have gone. You don't have to agree, but you should really engage the arguments on the merits. And I think you're seeing less of that commentary. And I do want to talk a little bit about the fact that people who comment on the court, people who are part of the public's understanding of the court, that's what we all do. We do have a unique obligation to do that in a way that does engage things on the merits, that is analytical and is not reflexive, and I think contributing to public misunderstandings of what is happening at the court.
Yeah, absolutely. I mean, I heard Greg earlier, maybe I misunderstood, but I heard him to be differentiating between attacking the legitimacy of the court, or I should say maybe even criticizing the legitimacy of the court would be a better way to put it, and criticizing or attacking the legitimacy of specific justices. And so I think that it's important to, as I think you're alluding to, Julie, for people in our position, for people in the position of responsible citizens, to depersonalize some of the reactions to the court's opinions. I mean, I hear people sometimes in the media, they just assume that if it's one justice writing a case that they're going to disagree with it, that we should all disagree with it, that it's, wrong and stupid and all these things. I do think one thing you mentioned is, that the court doesn't have to release all of these opinions at the end of June, and I think there's a question about the court's own practices and to what extent the court...
Although gratitude to get Kelly and the tariff case not at the end of the term. Mm-hmm. Right.
Yeah, absolutely. I mean, one thing that some people have proposed is, having the court sort of hold opinions and space them out so that there's more time for the public to digest them. I personally think it's good for the court to release the opinions as they become available, which is what they do. At the same time, I think that the justices could, as I alluded to before, could work to minimize the number of concurrences, dissents, the length of concurrences, dissents, and have the opinions come out during the course of the term at a sort of more regular clip. Another sort of that would be a large change. Another sort of small change that I think the court could do is so right now, you all probably know, the way that it works is that the court takes the bench to release opinions. The majority author will summarize the decision. Sometimes a dissenter will read a dissent from the bench. The oral audio, the live audio recording of that is not available until the next fall. And the court could put that out immediately. I mean, like I said, there's this hunger for sound bites, and for sort of quick summaries of decision that I think is totally understandable in our modern busy age, right, where people want to know what's happening immediately. And because the justices, they're sending out sometimes 200 or so page opinions into the world, and that's all we sort of have from them in a sense. People go immediately to commentators, and that's how they hear the Supreme Court opinions filtered through commentators who are sometimes partisan, sometimes not accurate. The court could release that audio itself, and people could hear quickly from the justice's own mouth what the court is doing. It's something that the Supreme Court press has been pushing for and has not had luck so far, but that's one sort of small thing that the court could do to make access to the substance of its opinions more available to the public.
What other changes do the rest of you think the court could make that could help improve the quality of the commentary and the public understanding of what the court's deciding? And Howard, you're looking at me, so I'm going to go with you first.
Oh, okay. Excuse me. I mean, I think just kind of piggybacking off of Catherine's point about the timing, they released 10 or 12 opinions in 3 days in the last week and a half of the term. And so, most of them were 80 pages and up, all the way up to the birthright citizenship case. That was about 190 with all these multiple opinions. It's impossible for the public to digest all that in a way to report on it. So you're going to kind of fall back to the simplest analysis of it: who won and who lost, who wrote the opinion. And so in a way, if we're worried about sort of a poverty of the way people talk about the opinions, in a weird way, the court is contributing to that by the way they release their opinions, because they're releasing it in a way that makes it impossible to have a different form of analysis. It lends itself to a little bit of conspiratorial thinking. It's like, okay, the birthright citizenship case was the last case announced on the term because the Chief Justice, it was the Chief Justice's opinion, so he's the last one to announce on opinion days. Did he hold it so that the last word on the term was the court stands up to the president on his signature initiative? In the cesspool that is social media, those ideas are gonna percolate, and so the court might think about how it's contributing to that impoverished discourse.
Jonathan, I know you have perspectives on this.
I mean, I agree with that. I think in general, in terms of how people perceive the court, one thing the court should do is take a lot more cases. And one reason I say that is because the role that the court plays, in our legal system is really not the final, arbiter of our most hot button political and social issues. I mean, that's what comes out at the end of June, because those are some of the cases the court has, and those are the cases that the justices may find the most difficult and where they might want to have the most incentive to write extensively. But, the bulk of what the court does in terms of ensuring uniformity in the application of federal law and in terms of figuring out what various federal statutes mean, figuring out how lower courts are going to help people and firms resolve disputes that they have within our legal system, is something that, the court's, in my view, primary role. And it's not as if there aren't lots of cases of a regular sort that it could take. And I think if the court took more cases, number one, the justices wouldn't be able to write 70-page concurrences, reminding their colleagues of all the times they had written prior opinions that seemed to conflict with what they were saying on this particular day. And there was a concurring opinion this term that I think was actually 60 pages that was just receipts. You all, either finally come around to my point of view or here are the... If they had the number of cases they had just 30 years ago, they wouldn't have time for that. But also then it would be much clearer that the bulk of what the court is doing is something that is, far more important in terms of the day-to-day legal life of our country than being the decider on, questions relating to, transgender athletes or citizenship, whatever else, and so on.
I want to get T-shirts made up that say "More cases, fewer concurrences."
So anyway, I think that would be good. I think the point about spacing the cases out, I think, is certainly a good one. There are multiple instances this term of cases from the last week where a lot of initial reports and a lot of characterizations on social media were just wrong. The Mississippi case was reported wrong by some outlets. The way the dissents, or what the dissents precise in the birthright citizenship decision actually said was misreported in a lot of places. And I think the time pressure and it being not just one case one day, but multiple cases on a single day contribute to that.
I'm going to Goldilocks the Supreme Court a little bit. So some of the opinions are too long, but on the shadow or emergency docket, maybe they're too brief, and there's less explanation, there isn't briefing, there's not oral argument. How is the shadow or emergency docket, and also I think the public attention to it, impacting perceptions of the court? And Jonathan, I'll start with you on this one.
Well, it's certainly impacting the court. My view, and there is a NCC podcast where Steve Vladeck and I debate this question. So if you want to hear the other side of what I'm going to say, go listen to that, and you can hear Steve say why I'm wrong. But I think the court is fundamentally a reactive institution, right? Unlike Congress and the president, the court has more limited ability to decide what it's going to do because people have to file cases. People have to file petitions for certiorari. People have to file petitions for some sort of emergency relief with the court. The court can't just generate them. And the court over the last several years has been trying to figure out how to respond to the fact that a lot more people, including the executive branch, are far more often coming to the court saying, we need you to resolve this right away because there's this injunction that was just imposed and the government's not allowed to implement this policy or the state's not allowed to do this. And the problem is that you have things that are coming under extreme time pressure, so you don't have the normal amount of time for briefing, argument, and consideration. And so it's difficult to generate the sort of opinions that we would get in other cases. It's also difficult to let some of these issues kind of gestate. We all know of cases where justices' initial views of how a case would come out ended up being different than what ended up happening. And there's kind of a percolation and gestation of issues that allows that to happen. Whereas if you ask justices to make a quick snap decision, they are much more likely to go with their ideological priors. If you want a lot more 6-3 right-left opinions, force the justices to make more decisions about more high-profile cases more quickly. And so there's a tension there. Because if they do something really quickly and they don't write and explain, because it's a tentative judgment, they don't want to lock themselves into something they're not sure of, well, then we're kind of left, well, you didn't explain it. And so we don't know what you did. And so I think the court's kind of in a tough place there. I think in recent years, it has taken more cases off the shadow docket and scheduled them for oral argument. It has slowly started to try and write at least a little bit more. I think those are positive changes, but there's some real pressures there because I don't think we would be happy with the sort of decision-making we would get if the court was trying to write opinions for everything it's dealing with on that docket. And by the nature of those petitions, it can't just ignore them.
Greg, I want to talk a little bit about the ways in which Supreme Court oral advocacy has changed. Everyone here, I'm sure, listens to the audio of oral arguments, or if you haven't, maybe you do, or you should. There's something that is happening in some oral arguments where it feels more casual. It is more conversational. Sometimes it's more strategic, and then sometimes, because there is awareness that the oral argument will be released. There are many people who think it should be released the day of. It's not. That some of the commentary, both from the justices and from the advocates, feels really pointed for audiences that may in fact exist outside of the courtroom.
Yeah, it could. More and more people are arguing more frequently before the court. There's a smaller bar, and there tends to be a greater familiarity with the justices, and that can change the nature of the dialogue a little bit. It can be very effective, and at times it can, maybe lead people to believe, give a different impression of how the court operates. I mean, first of all, for those who haven't listened to oral arguments, I would strongly encourage you to do so. I mean, the court really is a remarkably transparent institution in the sense you can listen to the oral arguments. They've got to explain their decisions, so it's all out there. Oral arguments have changed in the way that I suggested earlier with getting longer, and so I think this is another way in which the discourse on the court has changed. But just to make one other point more generally about the court, I do think it's important to understand, I think as Jonathan alluded before in talking about taking more cases, that the court still agrees more than it disagrees. Even Justice Jackson, who I think was in dissent the most this past term, was in the majority 67% of the time. From my standpoint, one of the things I love about the court is when the sort of most contentious hot-button cases are argued, everyone leaves the courtroom, the justices are there just as lawyers trying to figure out the cases no one's really going to read about. And so I think I wouldn't want you to leave the discussion here today and think that the justices are just angry at each other, angry about the court, angry about the results. That's not at all the way that the court operates and is as an institution, in my experience.
Coming to the end of our time together, and I just want to ask each of you about looking ahead to the next Supreme Court term. What will you be watching most closely when it comes to how the justices are relating to one another, how they're thinking or not thinking about the ways in which what they're saying, how they're saying it, and when they're saying it may impact the public's understanding, and then what you feel your responsibility as scholars and commentators on the court will be in the term ahead? Catherine, we'll start with you.
Wow, that's a big...
Sorry, big question.
Big, important question.
You have 3 minutes. Begin.
I mean, I'll just say that I think we've touched on some of the issues that may have changed the way that the justices relate to each other. Things like the changing shadow docket, things like the way that oral argument has changed, the Dobbs leak, for instance. I also think that, the fact that the justices went home during COVID and worked from home, the clerks did the same thing to a large extent, that sort of fragmented the court in a way. And you also had a big change in personnel at that time. Then during the few years after that, the court came back together. People maybe were playing extra nice because there was a new cast of characters. And so I'm interested in just continuing to see how people settle in oral argument, in opinions, and what kind of sort of shifting coalitions you see. So I'm sort of interested in like a sociological perspective of just watching the way that the justices continue to engage with each other on the court, in the opinions, off the court. I think I sort of touched on the way that I see our responsibility as legal scholars and commentators, so I won't belabor that point. I would also just encourage people, like people have said, there's so many different, podcasts, social media accounts out there. Listen to a wide range of podcasts. Read a wide range of commentators, especially law students out there, to get a broad view of what people think about and how they're analyzing the court.
Or to shamelessly plug the National Constitution
Yes,
Center. Come to one source that
absolutely.
brings those things together in one convenient location.
Yes, the National Constitution Center does a wonderful job of modeling civil discourse.
Jonathan.
Yeah, and one thing that I'll be looking at is the way that some of the issues that are beginning to emerge and confront the court aren't the issues that people were thinking about when they were nominating the judges that are now on the court. And that's something we've seen in various times through history, that kind of the issues that the White House is most concerned about, or the Senate's most concerned about when a judicial nominee is picked, are not the things that 5 years, 10 years later that are of legally of most important. And then that can lead to coalitions aligning that are not the ones we expect. And we saw some cases this past term like that, right? The big pesticide preemption case, the dissenters were Justice Jackson and Gorsuch. Right, that's, you wouldn't, if I told you there was a 7-2 opinion, you would not pick those two people as being the dissenters. So that's, in terms of obligations, it's certainly something I certainly always endeavor to do, and not saying I always succeed at it, but before explaining why I think a certain position is wrong, being sure that I understand it and can articulate it in a way that would be recognizable to someone who believes it. because that's really the test, because there's not a single justice on the court who's not intelligent, thoughtful, and who doesn't believe the things they're writing. They may sometimes be wrong, may be profoundly wrong, but they believe it in good faith. And I think a real test of those of us that want to be critical of the court is, can we, before we criticize, articulate the position we're going to criticize in a way that would be recognizable and would be endorsed by the person that holds that view. And I think that's something that is certainly worth aspiring to.
Greg.
Well, I have to be careful of being critical of the court because I appear before it. But I think in terms of what I'm interested in following is, we've talked a lot about the debates between the two different sides of the court, but really some of the most interesting debates are among the justices in each groups. And on the right, in particular, Justice Barrett, Justice Kavanaugh, are extremely interesting. Justice Gorsuch, Justice Barrett, I think, has had a really remarkable term, and so I'm interested to see that continuing of that group of justices. And on the left, there's a really interesting debate taking place, I think, in terms of those in the minority, in terms of what's the best way, the long-term way of dealing with the situation. Is it more pragmatic to try to limit results that they might disagree with, or is it more, we need to sort of call the court out more directly and say what we think is going on? And so I think, looking at that debate is really fascinating too.
Howard, last word.
I'm never going to appear before the court, so I can criticize them all I want. I think something that you said is very interesting, because I think it marks something of a divide between Justice Sotomayor and Justice Jackson on the one hand and Justice Kagan on the other, who seems more inclined to try to create some coalitions across jurisprudential divides. I think the thing to watch going forward is, how long do we have this court? Every time a justice changes, you get a brand new court because the interpersonal dynamics change. So how long do we have this same group of 9? Who is the new justice? One of the things that a lot of the discourse that we've been talking about the Supreme Court is also trickling down to the lower courts, and the lower court judges, one of whom is going to be at some point a new member of the Supreme Court. So how long, until we have a new court, and what does that look like?
Howard, Greg, Jonathan, Catherine, thank you so much for a really thoughtful conversation. I want to thank our partners at Texas A&M again. Neil, thank you so much for the partnership. Thank you all for being with us this evening. Take care.